It's rebuttal time.
All right, let's show 3 minutes for rebuttal then.
There's a fairly simple question in front of the court today, and it rests entirely on the Chancery Court's application of one case, which is Goodwin v. Metropolitan Board of Health. Before I get into that argument, I'd like to take you procedurally to the background on how this case started. Back in January 23 of 2017, Ms. Taylor was a long-term employee with Shelby County, working, I believe it was in HR. She was terminated from that position and exercised her right to appeal up to the Civil Service Merit Board of Shelby County. I was engaged to represent her at that hearing, and we had that hearing. At the conclusion of that hearing, the board then issued an order that fully returned her to work with an award of full back pay. Shelby County was dissatisfied with the decision of the Merit Board and appealed that matter to Chancery Court. Ms. Taylor responded to the petition filed, a petition for review filed by Shelby County, and that matter languished for approximately 5 years while my client is unable to return to work and is not receiving back pay. Shelby County let that matter sit there and didn't perfect their appeal. Eventually,
when you say they didn't perfect their appeal, they didn't file the record? Or?
Well, it was very interesting what happened here. They never set it for a hearing. After a period of 5 years has run by, I've had some experience. This court has had some experience with kind of a similar issue before in the case of Gary Morris. I knew that the longer that this went, the larger the back pay number is going to get for Ms. Taylor. And I began to remind Shelby County, after the Gary Morris decision came down from this court and went back to Chancellor Jenkins, I began to remind Shelby County, you have another one out there that you've let sit because they had to pay a large amount when this court affirmed the decision of the Chancery Court in Shelby County in the Gary Morris case. Eventually, Shelby County announced their decision. They were simply going to dismiss the appeal and that their proposed remedy for the dismissal was they were going to award Ms. Taylor back pay in the amount of the time from the day of the termination, which was January of 2017, until the decision of what they called the trial court, which is the Shelby County Merit Board, which is some 2 months later, which of course makes no sense since Ms. Taylor was unable to return to work to Shelby County for that 5 years while Shelby County processed their appeal.
At the point that they gave you the notice that they planned to non-suit and they were going to pay her a certain dollar amount, could you have requested a remand to the commission for determination about the actual amount of the back pay award?
I don't believe Shelby County Merit Board would have the jurisdiction on the back pay award from the period of time that the Court of Appeals had it in the bosom. Perhaps I could have asked, but there was a voluntary non-suit. They had the right to do that. When I learned that that was their position, we took action and we filed a counterclaim against Shelby County saying this is wrong. You shouldn't appeal a decision of a merit board. Nothing changed in the 5 years other than the clock ticking and the dollar amount running. That was the only change in 5 years. And then they decided to dismiss their appeal. Meanwhile, my client is just out here, sort of in outer space.
Let me make sure I understand your statement earlier. I said the commission, but I guess you mean the merit board. Could the merit board have determined the amount of the back pay award?
I've never seen the merit board determine the amount of back pay. If the way it generally works, and I've maybe done more merit boards in Shelby County than Ted Handsome in the last 20 years of anyone. The way it works is the merit board awards back pay. They get returned to work. The back pay is then set at that period of time from when you go back to work. That terminates back pay.
All right.
So whether Shelby County could have done the math and said, this is a 5 years that Shelby County has refused to allow Ms. Taylor to return to work. Did they have that? I don't know. That would require an order from the judge, right? The only mechanism to get this back into the merit board would be by order. I couldn't just go back and say, they've dismissed their appeal, I need you to determine merit board. I think it would have to be remanded back through some mechanism, which is why we filed the writ of mandamus. And so we filed the writ of mandamus to seek justice for Ms. Taylor, who's been out of work now 5-some years, and Shelby County has created a new fictional, and they tell you, a new method for determining back pay, which is only to the period that the merit board returns you to work, even if they won't return you to work, which they didn't. So that was filed. Chancellor Kyle was on the bench at that time. They filed their motion to dismiss early. Chancellor Kyle didn't hear it. He orders to mediation. We attempted to mediate the case. We came back. I came and asked for a special master simply to determine what a proper award of back pay would be in this case. And during the pendency of that, then Chancellor Newsom took over and decided to hear the motion to dismiss. And really the way Chancellor Newsom handled it was he really just punted to you. And what he said was, I wish I didn't have to tender the case to the Court of Appeals for determination, but unfortunately I do. We do. Thank you. And so that was where the judge went. Chancellor Newsom said, you're just going to have to send it up to the Court of Appeals because I can't figure it out. The basis for his granting of the dismissal of our writ of mandamus was only based on this Goodwin case. And when you read the order, that's all there is Goodwin. And the proposition of Goodwin is simply that somebody appealed something from a merit board and then strapped on a deck action into that. And so what the court found in Goodwin was your deck action requires a different standard of review than in an appeal, a petition. It was either a writ of certiorari or a petition for review to the merit board. Those are two different things, and we can't do that. Because, as you know, the merit board is just whether or not it was arbitrary, capricious, not based on substantial or material evidence or was made in bad faith. That's kind of the limit of the Chancery Court generally. And then when you start bringing other evidence, that's different. The problem here, in this case, is there is no conflicting standards of review. By Shelby County's dismissing their appeal, then there's nothing from the merit board to consider. That standard I just gave you about arbitrary, capricious, lacking substantial material evidence is not in front of the court anymore, right? The court is not looking at anything that the merit board did. Now the court is looking at Shelby County on the writ of mandamus to see what the right thing to do is for the client, and that's it. And that's why we're here today still, looking to do the right thing for the client. She was wrongfully terminated. Shelby County concedes it when they dismissed their appeal. The merit board found it. And so, you may ask this question, I'll answer it. The reason we had to go through the writ of mandamus process by way of counterclaim is that we were 5 years after the merit board had made their decision. We had no idea Shelby County was simply going to dismiss their appeal rather than give us an opportunity to be heard in Chancery Court, and then maybe it comes up here and maybe it doesn't come up here. But again, the only issue that the Chancellor has invited you to examine by making his ruling is whether Godwin v. Metropolitan Board of Health somehow prohibits him from hearing the case because of the competing standards on a petition for review versus the writ of mandamus that we filed as a counterclaim. 2 days after our counterclaim was filed, the petition for review is dismissed, making it a factual and legal impossibility that the court would wrestle with that issue. It was simply not an issue in front of the court.
So, Mr. Wells, if I'm understanding your argument, you're saying the court, obviously you said that Chancellor Newsom punted it to us. So it's your position that the court should have kept the case and granted the mandamus.
That's right.
And I guess specifically what I'm not following in your argument here is, why does mandamus lie in this situation? I mean, why does it lie, I guess is the best way to put it.
I guess the answer is to correct the wrong.
And what wrong is that specifically? What wrong are you, I mean, I followed what you know, about the procedures that you've stated up until this point, but what specific wrong are you wanting corrected, and what specifically do you want the trial court to do to correct it?
The wrong is the Shelby County's position regarding back pay. They have denied her the right to return to work for 5 years and denied her back pay for that entire period of time. That's the wrong. And it's a substantial wrong. She should have been returned to work. They decided to appeal it. That appeal precluded her from going back to work, and it precluded her from getting her back pay. Shelby County full well knew what the actual measure of back pay is, which is it runs through the pendency of an appeal, and then up here and back, because they've done it. This court has sent cases back, and they've had to do that math before. So the wrong is huge.
But in a mandamus action, can you adjudicate some amount that's owed, or are you simply normally just forcing a party to do something that's already been determined?
I think the court can calculate what the back pay is. And what the chancellor also didn't address was that there's a 1983 claim that somehow it was never addressed at all. It was really the writ of mandamus, but there were two actions filed. There was a 1983 claim against Shelby County and the writ of mandamus. And I think under either vehicle, the court can say, as a matter of law, here is how we calculate back pay. And we've also, and I know my time is up, we have asked this court to exercise its judicial discretion so that there's no longer a lack of clarity about what back pay is when a municipality appeals something, when back pay accrues and ends.
That would be advisory, wouldn't it? I mean, we are a reviewing court. We don't have a lower court order that says how you go about doing it.
At some point, somebody has to define it. That's right, Judge.
Okay, all right.
Thank you.
All right.
Good morning, Your Honors. My name is Jason Durrance from the Shelby County Attorney's Office. I'm here on behalf of the appellant, Shelby County. And I'll jump right into it, Your Honors. We have 2 points of disagreement, or broadly 2 points of disagreement with appellate's case. First, we believe that the Chancery Court, acting in an appellate capacity, did correctly apply the case of Goodwin to the case at bar, and that ruling should stand. And secondly, Your Honors, even if this court disagrees with the application of Goodwin in the Chancery Court, mandamus is not appropriate here. Appellant has not made a sufficient legal case for mandamus. Mandamus should not lie. Your Honors, appellant seems to try to distinguish this case from Goodwin, or state that Goodwin is not applicable here because, at least in part, the county dismissed its appeal of the CSMB ruling. That dismissal does not affect the Chancery Court's jurisdiction to hear a writ of mandamus flowing from a CSMB ruling. To look at it logically, any appeal that comes before Your Honors cannot have a cross-claim for new relief attached to it. If an appellate in this court dismisses their appeal, the appellee is then not empowered to ask this court for new relief in the form of mandamus. The Chancery Court, per statute, only had jurisdiction over this entire legal proceeding as a appellate body reviewing the CSMB's ruling. Once that appellate jurisdiction went away, the Chancery Court has no more jurisdiction to look at, review, or otherwise alter the CSMB's ruling. And let's be very clear here. What appellant is asking for is an alteration of the CSMB's ruling. Nowhere in the some 80 pages of the CSMB hearing transcript and exhibits did appellant state how much she believes she is owed in back pay. Nowhere in any part of this process, any of the memorandums before the Chancery Court, any of the briefing here, has appellant stated how much she believes she is owed in back pay. That means there will have to be a factual determination of how much Shelby County allegedly owes in back pay to
And what is the procedure for doing that?
The procedure, Your Honor, is set out in Tennessee Code Annotated 4-5-322E. That part of the statute states that if it is shown to the satisfaction of the reviewing court that there is additional evidence needed or may be material to the underlying appeal, that the court may order that the additional evidence be taken before the agency upon conditions determined by the court. Now, Your Honor, Judge Armstrong asked appellant if they could have requested a remand to the CSMB to make this determination of how much is owed in terms of back pay. He absolutely could have, per that statute that I just cited to you. And again, we brought this statute up as an argument in the alternative before the Chancellor to show that if the Chancellor had any question, or if appellant had accurately raised any question of back pay in this case, that is for the trial court, in this case the Civil Service Merit Board, to determine. It is not the job of the Chancery Court sitting in appellate posture to make a new ruling on new facts as to what the exact amount of back pay should be, any more than it would be this court's job to make a ruling in the first instance as to the amount of back pay that may be due to an appellant in this court. And so, Your Honors, we believe that the Chancery Court, in its appellate capacity, properly applied Goodwin, and that this court should rely on Goodwin as well. Your Honors, the Goodwin case does not stand for simply the proposition we do agree with appellant that Goodwin stands for the proposition that an appellate court should not mix the procedural postures and standards of an appellate review with the question of fact in the first instance when acting as an appellate court. Where we differ, Your Honors, is that the writ of mandamus is in and of itself, or the petition for writ of mandamus in and of itself, opens up a new fact question. That brings me to my second point, that even if this court determines that Goodwin is not applicable and that the court, or the Chancery Court, should have addressed the question of mandamus, the mandamus should not lie here. Your Honors, as we stated in our brief, Cate of State Ex Rel Weaver versus Ayers lays out part of the standard for mandamus. It states that mandamus shall only lie to enforce a ministerial act or duty, and it can only lie where the law prescribes and defines the duties to be performed with such precision so as to leave nothing to the exercise of discretion or judgment. Here, Your Honors, there is a very big question left to, apparently, if appellant has their way, the Chancery Court acting in an appellant capacity. That question is, how much does Shelby County actually owe in back pay? Now, Shelby County has taken the position that back pay runs from the date of termination to the date of trial. That's a pretty cut and dry, logical position to take, given that a trial court, in this case the CSMB, can't really rule on or grant damages for things that have not occurred when they make their ruling. In terms of what happens after that judgment is entered, that's what post-judgment interest is for. I'll point out that the Shelby County, in its attempt to settle this issue with with the appellant, we offered 2 separate checks, one for back pay, one for post-judgment interest. If appellant now wants to challenge, or really for the first time, offer a differing number as to back pay, that's a fact question. It's a question that's unanswered right now, and therefore it's not a proper question to come before the court on a writ of mandamus. The Weaver case also makes the statement that I really think is sort of puts a button on this issue, is that mandamus is to execute, not adjudicate. Here, going back to the original order that's being appealed, that's the CSMB's ruling, there is no amount of back pay put into that order that any court could then order Shelby County to execute on. Again, in the 80-some-odd pages of transcript and exhibits from the CSMB hearing, there is not one shred of proof as to how much appellant was making when working for Shelby County. No calculation as to what sums should be deducted from a potential back pay award, things such as pension payments she would have made, deductions for health care, etc. There is absolutely nothing in the record, which both this court and the Chancery Court were bound to. There is nothing in that record that would allow anyone, this court or the Chancery Court, to calculate an amount of back pay. That being the case, what appellant is asking for is a new adjudication of a specific back pay amount. Such an adjudication, as the Supreme Court tells us in Weaver, cannot happen as part of a mandamus petition. And finally, Your Honors, I'll address this issue that appellant raises as to the overall legal definition of back pay. And now this was not one of the questions presented in appellant's brief. He did raise it, I believe, in the last paragraph of his brief in principle, stating that this court could use its inherent discretion to define when back pay runs. I've got good news. This court has already done that. In the case of Gorey versus United Parcel Services, 490 Southwest 3D 413 from 2015, this court stated, back pay is calculated between the date of discharge and the date of trial. Your Honors, for whatever, to the extent that appellant has raised that issue in their brief or otherwise, this court has addressed that issue. And again, it's eminently logical for an award of damages to only run for the time period where the court can actually hear proof on what damages should be. Post-judgment interest, as I understand it, is specifically to make a prevailing party whole in the event the judgment that they have won is not paid on immediately or soon after they have in fact prevailed. To the extent appellant disagrees with the sum originally tendered by Shelby County in terms of back pay, it's on her to prove that figure. It was on her, the appellant, when she came before the CSMB in the first instance. It's been on her the entire time. She has not put that proof on the record. If appellant wants to do so, there is the mechanism I cited, Tennessee Code Annotated 4-5-322E, that specifically contemplates that additional proof may be needed in an appeal to Chancery Court from an administrative action. Appellant did not avail herself of that potential for remand. Instead, she attempted to tag on, again, a new action requiring new proof at the appellant stage. Simply put, Your Honors, we do not believe that this was an appropriate use of a petition for mandamus. We believe that the Chancery Court in its appellate review got it absolutely right in applying Goodwin. And I know that opposing counsel described that as a punt. I would encourage the court to read the entire order from the Chancery Court and the transcript of the judge's oral ruling from the bench. He certainly understood that the parties would be taking a trip up to Jackson, but I do not agree with the characterization that there was any sort of punt or hand-waving away in the chancellor's determination. Goodwin applies here, Your Honors. The law, black-letter law cited that governs the appellate procedure of a appeal of a administrative decision to Chancery Court applies here. And even if you don't agree with me with those 2 points, the Supreme Court statements as to when mandamus should lie certainly apply here. And based on those statements from cases like Weaver, this is not an appropriate circumstance for mandamus. And so we would ask the court to affirm the Chancery Court's ruling and deny appellant's request to have that ruling set aside. If there are any further questions, I'd be happy to take them now.
Don't see any. Thank you.
Appreciate your time, Your Honors. Thank you very much.
Thank you. I'll try to be brief and address just a couple of the issues raised by Shelby County. One being that there was no way to calculate what the back pay amount is. Shelby County has already done that. They told you what post-judgment interest, what that is, and they also told you what period of time they calculated the award of back pay. So the issue is not the amount. There is no burden on behalf of a party that's been terminated to prove up the back pay. The issue that goes in front of the Chancery Court on the review is whether or not the termination was proper. If it is, then back pay gets awarded, and the Chancery Court does that. The person that lost the job doesn't have to go back before the hearing where they want to apply this 322E to somehow apply that. That's pre-hearing on a petition for review. There is no petition for review here. I would say just a couple of other things. One, neither the court nor Shelby County has addressed the idea that there is a 1983 claim that has been dismissed for no justification at all, that was filed to try to protect my client's rights for the fact that she was denied work for 5 years and denied back pay for 5 years. I would also point out that the fact when the word punt is because what the court says, I wish I didn't have to tender the case to the Court of Appeals. That's language I'm quoting from the judge. I didn't make that up. I don't know how it's a mischaracterization. And finally, I think mandamus does lie. I think there are 3 elements. If you look at peerless construction v. Bass, and I've cited it first, the plaintiff must have a clear right to relief. That right to relief is back pay for being denied work for 5 years. Second, the defendant must have a clear duty to perform the act. The duty is on Shelby County to say, you know what, we shouldn't have kept you away from work for 5 years, and now we're going to give you back pay for the period of time up until the merit board. And finally, third, there must be no other adequate or specific remedy. Their argument that the remedy under the statute 4.5 falls because that is not a remedy that was available once you dismiss the petition for review. There is no remedy to go back, as they argue under 4.5, 322E, because there is no petition for review, so there is no argument, hey, Judge, we may have some specific needs for additional evidence, and we'd like to tender that back down to the merit board for hearing, because that action was no longer alive by choice of Shelby County when they decided to voluntary non-suit. And so at the end of the day, we're simply asking that this court, they have calculated back pay for you. We're asking the court to return this back to Chancery Court so the matter be heard, we can get back pay set, and my client can be made whole. I appreciate your time.
Thank you. All right. All right, we'll take your case under advisement and work to get you an opinion. Thank you.
Thank you.
I think that ends the docket for this morning, and we can stand in recess.